Welcome to the webinar on Companies Amendment Ordinance 2023, organized by the Companies Registry. The webinar is about to begin. Before we start, I would like to brief you on today's rundown. As you can see in the program on screen, our speaker will first give the presentation on relevant topic. After the presentation, there will be a Q&A session. If you have any question on today's presentation, you can raise it anytime during the webinar using the Q&A feature. The PowerPoint slide for the presentation will be available for download at the website of the Companies Registry after the webinar. Without further ado, I would like to invite Ms. Mandy Lam, Solicitor of the Companies Registry, to give the presentation on overview of the Companies Amendment Ordinance 2023 and good practice on holding virtual or hybrid general meetings. Ms. Lam, please.
Good morning, everyone, and welcome to this webinar. If you have any questions, please feel free to type them in anytime during my presentation, and I will try to answer them in the Q&A session. Okay, we can start now. In part one of this webinar, I will talk about the Companies Amendment Ordinance 2023. First of all, let me give you some background information about the Amendment Ordinance. Regarding general meetings, the Companies Ordinance provides that a company must hold an annual general meeting within the prescribed time. According to Section 610, a private company and a company limited by guarantee must for each financial year hold an AGM within 9 months after the end of its accounting reference period. And any other company must for each financial year hold an AGM within 6 months after the end of its accounting reference period. A company may also hold a general meeting out of its own initiatives from time to time as necessary. For example, on alteration of the company's articles of association, change of company name, and share buyback, etc. The manner of holding a general meeting is governed by the provisions in the CO and the company's Model Articles Notice, that is CAP 622H, and also provisions of the company's own articles. In the CO rewrite exercise in 2012, Section 584 was introduced. It expressly provides that a general meeting may be held at 2 or more places using any technology that enables the members of the company who are not together at the same place to listen, speak, and vote at the meeting. But there is no specific provisions for a company to hold fully virtual general meetings or the hybrid mode of virtual and physical general meetings. Since the rewrite exercise, electronic communication technology has advanced much further, and this allows individuals to participate in virtual meetings more conveniently and effectively. Mobile applications and devices are also widely adopted around the world in holding and joining virtual meetings. Also, a number of comparable common law jurisdictions have already introduced specific legislative provisions, allowing companies to hold general meetings virtually or in hybrid mode, instead of just at physical locations. For example, in the UK Companies Act 2006 provides that persons who are not present together at the same place may by electronic means attend and speak and vote at general meetings. In Australia, some temporary amendments have been made to the Corporations Act 2001 to enable companies to hold virtual or hybrid general meetings. And these amendments have become permanent with effect from the 1st of April last year. In Hong Kong, there were suggestions from the Company Governance Trade to review the provisions in the CO on the mode of general meetings. The industry suggested making express provisions that enable companies to conduct fully virtual or hybrid general meetings. Having taken into account local stakeholders' views and international practices, the government considered that there was a need to modernize the CO to expressly cater for the scenario of companies holding fully virtual or hybrid general meetings. And therefore, the Companies Amendment Bill 2022 was introduced to the Legislative Council. The bill seeks to amend the CO and the model articles to facilitate the holding of general meetings by using virtual meeting technology. This would provide flexibility for companies to conduct corporate affairs smoothly and effectively, having regard to their own needs and circumstances. Regarding the proposed legislative amendments in the bill, the government has consulted the Standing Committee on Company Law Reform and also stakeholders such as the Hong Kong Chartered Governance Institute and the Chamber of Hong Kong Listed Companies. They all welcome this facilitative proposal. The bill was eventually passed by the Legislative Council on the 18th of January this year, and has become the Companies Amendment Ordinance 2023. The Amendment Ordinance was published in the Gazette on the 27th of January and will come into operation on the expiry of 3 months after the gazettal date, and that is on the 28th of April. This is to allow sufficient time for the trade to prepare and communicate with its members. I will now go on and talk about the details of the Amendment Ordinance. As I said, the Amendment Ordinance has introduced amendments to the CO and the model articles, which includes introducing new provisions and also amending some existing provisions. In Section 547, Interpretation, we have added a new definition of virtual meeting technology, which means a technology that allows a person to listen, speak, and vote at a meeting without being physically present at the meeting. We have amended Section 573, which is about publication of notice of general meeting on website. Before the amendment, this section provides that when a company notifies a member of the availability of a notice of general meeting on a website, the notification must specify, among other matters, the place of the meeting. And after the amendment, the notification must specify the physical venue of the meeting or the virtual meeting technology to be used for holding the meeting, or both. And Section 576 is also amended. This section is about the contents of notice of general meeting. Before the amendment, this section provides that a company must ensure that a notice of a general meeting specifies, among other matters, the place of the meeting. And after the amendment, the company must ensure that the notice specifies the physical venue of the meeting or the virtual meeting technology to be used for holding the meeting, or both. A new subsection 2A is also added here to provide that the notice may specify the virtual meeting technology to be used for holding the meeting, unless the company's articles expressly preclude the holding of a general meeting by using virtual meeting technology, or require a general meeting to be held only at a physical venue. This new subsection also makes it clear that a provision in the company's articles requiring a notice of general meeting to specify the physical venue is not in itself requiring general meetings to be held only at a physical venue. A new section 583A is also added. This section sets out the mode of holding general meetings. It provides that a company may hold a general meeting at a physical venue, that is a physical meeting, or by using virtual meeting technology only, that is a fully virtual meeting, or both at a physical venue and also by using virtual meeting technology, that is a hybrid meeting. Some new provisions have also been added to this new section 583A. They are similar to those in section 576, bracket 2A that I have just mentioned. In short, the new provision provides that a company may hold general meetings using virtual meeting technology if there is no provision in its articles which preclude this being done, and there is also no provision in its articles which require a general meeting to be held only at a physical venue. And similarly, any provision in the company's articles which requires a notice of general meeting to specify the physical venue of the meeting is not in itself a provision that requires a general meeting to be held only at a physical venue. The purpose of these amendments here is that companies will be able to benefit immediately from the newly introduced flexibility on holding virtual general meetings without having to go through any amendment procedure to their existing articles. Amendments have also been made to the existing section 584, which is on meeting at 2 or more places. In the heading of this section, the word places is amended to physical venues. And this is to make it clear that we are talking about physical venues here in this section. This section provides that when general meeting is held at 2 or more physical venues, the company must use technology that allows the members who are not together at the same physical venue to listen, speak, and vote at the meeting, regardless of whether virtual meeting technology is also used for holding the meeting. The technology that is referred to in this section is the technology which is used to connect two or more physical venues for the meeting. And the requirements on this technology are the same as those for virtual meeting technology, which needs to allow members to listen, speak, and vote at the meeting. For section 585, which is on quorum, a new subsection 4A is added. It provides that a person who attends a general meeting by using the virtual meeting technology specified in the notice of meeting is to be regarded as being present. And now I will talk about the key amendments to the model articles. For the model articles that is in Cap 622H, there are 3 schedules. Schedule 1 is the model articles for public companies limited by shares. Schedule 2 is the model articles for private companies limited by shares. And Schedule 3 is the model articles for companies limited by guarantee. Amendments have been made to all these 3 schedules, and they are just consequential amendments to the CO. These amendments involve, for example, adding the definition of virtual meeting technology, and a notice of general meeting must also specify the virtual meeting technology if it is used for holding the meeting. And a person is regarded as being present at the meeting if he or she attends the meeting by using the virtual meeting technology specified in the notice. Some consequential amendments on Articles 46 of Schedule 1 and Articles 42 of Schedules 2 and 3 have also been made. This article is about adjournment of general meetings. In the case where a general meeting is adjourned, the directors or chairperson must specify the virtual meeting technology to be used for holding the adjourned meeting, if there is any. And if a person uses that virtual meeting technology to attend the adjourned meeting, the person will be regarded as present. In view of the amendment ordinance, we have issued a guidance note on good practice on holding virtual or hybrid general meetings. This guidance note will become effective on the same day when the amendment ordinance comes into operation, and that is on the 28th of April this year. The guidance note provides some general information and good practices on the holding of fully virtual or hybrid general meetings by locally incorporated companies. Companies may refer to the guidance note and should choose the most appropriate mode of meeting that best suits their needs and circumstances. Apart from convening a valid meeting in accordance with the law and their articles, companies should consider whether a physical meeting continues to be the most appropriate mode, or holding a fully virtual or hybrid meeting may promote better engagement with members and maximize participation. Now, in part 2, I will talk about some important aspects in this guidance note. And this will include some statutory provisions on the holding of general meetings in general, and also some good practices for holding virtual or hybrid general meetings. Firstly, regarding the notice of general meetings. Section 571 of the CO provides for the notice period. An AGM of a company must be called by notice of at least 21 days. For other general meetings, the notice period is at least 14 days for a limited company and at least 7 days for an unlimited company. If the company's articles require a longer period of notice, then the meeting must be called by the longer period of notice. On the service of notice, Section 572 states that the notice can be given in hard copy form or in electronic form, or by making it available on a website, or partly by one of those means and partly by another. Companies should also comply with Part 18, which is about communications between a company, its members, and other persons. If the notice of general meeting is made available on a website, it is good practice to dedicate a section or web page of the company website to inform members in a timely manner the details of the meeting and any further updates and changes. Regarding the contents of notice, Section 576 provides that all notices of general meetings must specify the date and time of the meeting, specify either or both the physical venue and the virtual meeting technology to be used for holding the meeting. And if 2 or more physical venues are specified in the notice of meeting, the notice must specify the principal venue and the other venues of the meeting. The notice must also state the general nature of business to be dealt with at the meeting, and state that the meeting is an AGM if the notice is for calling an AGM. If a resolution is intended to be moved at the meeting, the notice of meeting must include the notice of the resolution. And if a company is not a wholly owned subsidiary, the notice must include a statement containing the information and explanation that is reasonably necessary to indicate the purpose of the resolution. And here, items A, B, and C are subject to the provisions of the company's articles, which means that in case of inconsistency, the company's articles shall prevail. Section 597 of the CO provides for the statements required to be contained in a notice of meeting. It is stated that in the notice calling a general meeting, there must appear with reasonable prominence a statement informing members of the following matters. Firstly, the right to appoint another person, whether a member or not, as a proxy to exercise all of or any of a member's right to attend, speak, and vote at the meeting. Secondly, for a company having a share capital, a member may appoint separate proxies to represent respectively the number of shares held by the member that is specified in the instruments of appointment. And thirdly, For a company limited by a guarantee, if the company's articles require a proxy must be a member of the company, then only a member of the company may be appointed as proxy. In drafting the notice, it is good practice to use plain and simple language and avoid legal jargon. The information should also be presented in an easy-to-read manner. For example, headings and numberings should be used where appropriate. Companies should ensure that the information contained in the notice of meeting is accurate and complete in all material aspects. If virtual meeting technology is to be used for holding a fully virtual or hybrid general meeting, it is good practice to provide detailed information on the meeting arrangements in the notice of meeting. For example, the arrangement for members to attend the meeting using the virtual meeting technology, such as the link to access a live webcast. What the technology may cover. For example, whether the technology will allow members to ask questions both orally or in writing and cast their votes. The device members need to participate in the meeting, such as desktop computer, laptop, tablet, or mobile phone. If pre-registration and verification are required, the relevant information for members to pre-register and verify their identity for access to the meeting. If members are required to download or install a specific software or app for using the virtual meeting technology to attend the meeting, clear instructions as to how to download or install the software or app should be provided as well. Companies should also provide instructions to members on how members may access to documents such as proxy forms or other information relating to the business to be dealt with at the meeting. How members may submit proxy forms to appoint proxies and corporate representatives. How members may participate in the meeting, including the option to submit their questions prior to the meeting or raise questions at the meeting. For example, by dial-in conference call or video conferencing. The deadline for submission of questions and how relevant questions would be responded to should also be specified. The instructions to members should also cover how members may contact technical support for troubleshooting before and during the meeting, if this is available, and also how members can cast their votes, for example, through an online electronic voting system or app. Some tips to note can also be provided to the participants to inform them that a reliable internet connection which is fast enough to support video streaming and participation is required. If the internet connection is not fast enough to keep pace with the proceedings of the meeting, some parts of the meeting may be missed. And also, if internet connection is inadequate or interrupted, attendance at the meeting may terminate, and the participants' ability to ask questions or vote may also be affected. For documents that are required to be provided or laid before a general meeting, such as the financial statements of the company, proxy forms, etc., it is good practice to send such documents together with the notice of the meeting. Companies should consider using electronic communication as far as practicable, if this is permitted under Part 18 of the CO and the company's articles. This is to facilitate members' timely access to the documents and information relating to the general meeting. In the case of a physical or hybrid general meeting, it is good practice to arrange the meeting to be held at a time that is convenient to the largest possible number of members to attend at the physical venue. To maximize members' participation, companies may consider holding a fully virtual or hybrid general meeting by using virtual meeting technology. That is a technology that allows a person to listen, speak, and vote at the meeting without being physically present at the meeting. And this will give members the option to participate in the meeting virtually. In deciding the mode of holding general meetings, companies should aim to promote engagement with members and encourage their participation at the meetings. Companies should opt for the most appropriate mode of meeting, having considered the best interest of their members. It is important that the mode of meeting should not be a means of managing attendance or limiting the ability of members to participate in the meetings and to raise questions. In considering the mode of holding general meetings, companies may also need to assess their own situations, such as their members' base and profile, and also resource restraints. For example, while the costs incurred for holding a physical general meetings by some companies with a large number of members may be saved by holding virtual general meetings, it may not be cost-effective for other companies, especially in the case where the costs involve engagement of service providers to supply the hardware and software required for conducting such meetings. Different types of virtual meeting technology are available in the market to facilitate holding of general meetings. In choosing the technology for holding a general meeting, companies may consider some of the following factors. How much will the technology cost? How many attendees are expected? And what is the limit on the number of participants for the technology to be used? How long is the meeting expected to run? And is there a time limit on the length of the meeting for the technology? Will there be any help and support available to companies for holding meetings using the technology? What are the features available to facilitate presentation and participation at the meeting? And how are the features on facilitating access, verification of identity of participants, and voting included in the technology? Companies are advised to consider and mitigate any possible risks of holding a fully virtual or hybrid meeting, such as inadequate or unstable internet connectivity. To maximize the likelihood of connection issues, companies may consider providing a way for members to check their devices for connecting to the technology in advance of the meeting. Companies may also consider providing technical support to members who may encounter technical difficulties before or during the meeting. Companies should enhance transparency and accountability to ensure that members are properly informed and they can cast their votes in a well-informed manner. Security and authentication are crucial considerations when a virtual meeting is held. Companies should consider implementing necessary security measures to ensure that no unauthorized persons are allowed to attend the meeting, and members with the right to attend are not excluded. If a fully virtual or hybrid general meeting is held, and registration and authentication of members are required, companies should provide their members with the relevant information for registration and authentication before the meeting. For example, if registration and authentication are through an online electronic platform or website using login details provided by the company, each member should be provided with the invitation link to the platform or website, together with a meeting login ID and a password, and if possible, the login ID or password that is unique to that member. Other security methods of authentication, such as SMS and email authentication by sending one-time unique personal identification number to a member's phone number or email address, may also be used. However, it is important that the registration and authentication process should be simple in order not to become an attendance barrier. For meetings using video conferencing software, the host of the meeting may adopt some security measures. For example, setting up a unique meeting ID as well as strong and unique password for the meeting. If possible, arranging one or more hosts to deal with technical and other contingent issues during the meeting. Setting up a virtual waiting room and validating participants' identities before allowing them to join the meeting. Locking the meeting when all participants have been admitted to prevent unauthorized access. Informing participants and obtaining their consents before recording the meeting. Participants of general meetings who use video conferencing software should also pay attention to the security measures to be adopted. Therefore, it is good practice for companies to remind members not to share invitation links, meeting ID, and password or access code to anyone else, and to ensure that up-to-date security software, such as antivirus software, has already been installed to their connecting device. Participants of the meeting should also be reminded to ensure that video conferencing software is up to date, and the latest security patches have been installed. In case of confidential and sensitive information, participants should be reminded to join the meeting from a secured location where nobody else can access. But it is important that security and authentication measures should not be used as a means to deprive or limit members to attend the general meetings. Where a fully virtual or hybrid general meeting is held, the virtual meeting technology used for holding the meeting must allow a person to listen, speak, and vote without being physically present at the meeting. It is preferable for the meeting to be accessible in both video and audio formats. Companies are encouraged to use tailored and high-performing virtual meeting technology that best suit their circumstances for conducting the meetings. Companies should also ensure the adequacy of functionality of the technology used to enable members to follow the proceedings of the meeting and participate in the meeting uninterrupted. Regarding quorum, you may refer to Section 585 of the CO. It is provided that where a company has more than one member, subject to the provisions of the company's articles, 2 members present in person or by proxy is a quorum of a general meeting of the company. As I've mentioned earlier, the amendment ordinance added a new provision to provide that a person who attends a general meeting by using the virtual meeting technology specified in the notice of the meeting is to be regarded as being present. Therefore, all persons attending the meeting virtually at the time that the quorum is called must be counted for the purposes of determining whether there is a quorum. Members should have the right to speak at a general meeting. For any virtual element of a general meeting, it is preferable for the virtual meeting technology used can allow members to submit real-time questions during the meeting orally and also electronically by typing into a dedicated meeting application or platform. It is good practice to give the opportunity to members to submit questions before the general meetings. Members should be provided with a clear time frame as to when and where questions should be sent. Members should also be allowed to submit the questions by electronic means. Companies are encouraged to respond to all substantial and relevant questions promptly. And in order to facilitate members' vote, companies may consider answering questions ahead of the general meetings if practicable. For example, by publishing the answers on the company's website. These provisions in the CO are in relation to proxy. Regarding appointment of proxies, Section 596 of the CO sets out a right to appoint proxy. This is related to the other section 597, which is about the statement of rights required to be contained in the notice of general meetings. And the two sections are very similar, so I will not repeat again here. Section 599 of the CO provides that if an electronic address is stated in an instrument of proxy or invitation to appoint a proxy issued by the company is regarded as having agreed that any document or information relating to proxies for that meeting may be sent by electronic means to that address. And Section 601 provides that where an instrument of proxy is issued to a member for use, such instrument must enable the member, according to the member's intention, to instruct the proxy to attend and vote in favor of or against each resolution dealing with any business to be transacted at the meeting. Members attending a general meeting virtually should be able to cast their votes by electronic means in real time during a fully virtual or hybrid general meeting. Whether members cast their votes electronically or otherwise, companies should ensure that the necessary safeguards are implemented to validate votes submitted by their members. For example, where an electronic voting system is used, it should accurately count all votes cast at the meeting and provide record for verification purpose. Companies are encouraged to give an electronic address in an instrument of proxy or invitation to appoint a proxy issued by the company, so that their members may send the instrument of proxy to that address by electronic means. Where technical support is available for troubleshooting in case technical issues arise, this support should be made available to members both online and via a telephone number free of charge if practicable. Companies should also consider contingency planning for technical issues, for example, by providing alternative means such as dial-in or teleconferencing facility to allow members to continue to participate in the meeting if internet connection is lost or disrupted. If technical issues cannot be overcome in a short period of time or result in a number of members being unable to participate in the meeting, companies should consider adjourning the meeting until the issues are resolved. Regarding listed company, as defined in the CO, that is to say, a local incorporated company that has any of its shares listed in a recognized stock market. Apart from our guidance note, these companies may also refer to the Guide on General Meeting issued by the Hong Kong Exchanges and Clearing Limited, and also any updates. And I understand that this guide has been updated recently, and some guidance on fully virtual or hybrid general meetings have been included. If you wish to obtain more information about this topic, please visit the new thematic section on our website. And the external circular, FAQs, and our guidance note are all uploaded on that thematic section. This is the end of my presentation. Thank you very much.